Judge Sarah Chen just issued the final ruling that eliminates Trump's last remaining defense strategy. In a 91-page decision filed at 3:42 p.m. on February 11th, Federal District Judge Chen denied Trump's motion to exclude 847 documents that form the cornerstone of his entire defense theory, ruled that Trump cannot claim he relied on advice of counsel because he waived that privilege through public statements and rejected his emergency request to delay the March 18th trial date. And this isn't one setback among many options still available. This is the complete destruction of Trump's final viable path to acquittal after every other defense theory has been systematically eliminated over the past 8 months. When a federal judge issues what legal experts are calling a total defense annihilation ruling that forecloses your last remaining argument and does so with language suggesting the motion was frivolous, your legal options just went from slim to non-existent. Hit that subscribe button right now because you won't want to miss any of the videos I release. So, what makes this ruling so devastating? According to legal analysts who reviewed Judge Chen's 91-page opinion, Trump's defense team had abandoned earlier strategies, presidential immunity, selective prosecution, and venue challenges after courts rejected them. They pivoted entirely to an advice of counsel defense, claiming Trump relied on lawyers who told him his conduct was legal. But Judge Chen's ruling holds that Trump waived attorney-client privilege by repeatedly discussing his lawyer's advice in public statements, interviews, and social media posts. This isn't just a technical evidentiary ruling or a procedural setback. Legal experts say this is the equivalent of a boxer entering the final round, having lost every earlier round, planning everything on a knockout punch, and having the referee disqualify that punch before it's thrown. And believe me, when your last defense strategy gets eliminated by judicial ruling 1 month before trial, you're not going to trial with a viable defense. You're going to trial defenseless. Here's the full picture of what's been unfolding. Trump's legal strategy has evolved dramatically since his indictment in March 2024, with each successive defense theory collapsing under legal scrutiny. Initially, Trump claimed absolute presidential immunity, arguing former presidents cannot be prosecuted for official acts. The Supreme Court rejected that sweeping claim in July 2024, holding immunity is limited and fact-specific. Trump then pivoted to selective prosecution claims, alleging he was targeted for political reasons. Judge Chen denied that motion in September 2024, finding no evidence of discriminatory intent. In November 2024, Trump challenged venue, claiming he couldn't get a fair trial in the jurisdiction where the alleged crimes occurred. Judge Chen rejected that argument, noting venue is proper where crimes were committed regardless of defendant's popularity. By December 2024, Trump's legal team had exhausted their procedural and immunity-based strategies. They needed a defense that went to the merits, something explaining why Trump's conduct, even if proven, wasn't criminal. That's when they committed entirely to the advice of counsel defense. The strategy was elegant in its simplicity. Trump would argue he consulted multiple attorneys, disclosed all relevant facts, received legal opinions, that his planned conduct was lawful, and relied on that advice in good faith. If jurors believed Trump genuinely thought he was acting legally based on counsel's guidance, they might acquit even if they believed Trump did what prosecutors alleged. Smash that like button if this is making sense so far. Here's where it really gets serious. The advice of counsel defense has strict requirements. Defendants must prove they made full disclosure to their attorneys, received clear advice that the conduct was legal, and relied on that advice in good faith. Most importantly, asserting the defense waives attorney-client privilege for the communications at issue, because defendants can't claim they relied on advice while keeping that advice secret from the jury. And let's be honest for a moment, waiving privilege is extraordinarily risky. It means prosecutors can cross-examine Trump's attorneys about everything Trump told them, every warning they gave, every instance where Trump ignored their advice. Defense teams only pursue advice of counsel defenses when they're confident the privileged communications support their narrative. Trump's team apparently believed they could control the waiver, disclose favorable advice while protecting unfavorable communications. Here's what Judge Chen's ruling reveals about how this strategy collapsed. On January 15th, Trump's legal team filed a 178-page motion formally asserting the advice of counsel defense and designating 5 attorneys whose advice Trump allegedly relied on. The motion included declarations from 3 of those attorneys stating they advised Trump his conduct was legal. Prosecutors immediately filed opposition on January 28th, arguing Trump had already waived privilege through public statements and that his selective waiver attempt was legally improper. The brief included 47 pages of exhibits. Trump's social media posts, interview transcripts, and rally speeches where Trump discussed his lawyer's advice in detail. Sources who reviewed the prosecutor's filing told The Washington Post it was the most comprehensive privilege waiver compilation they'd ever seen, documenting dozens of instances where Trump publicly disclosed attorney-client communications. Meanwhile, Trump's attorneys scrambled to respond, filing a reply brief on February 3rd, arguing Trump's public statements were too vague and general to constitute waiver. They claimed Trump mentioned receiving legal advice, but never disclosed the specific content of privileged communications. Judge Chen scheduled oral argument for February 8th, signaling through the scheduling order that she viewed the waiver issue as potentially dispositive of the advice of counsel defense. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely devastating. The February 8th hearing, which lasted nearly 4 hours, became what legal observers described as a systematic dismantling of Trump's position. Judge Chen began by asking Trump's lead attorney whether Trump had, in fact, made public statements discussing his attorney's advice. When the attorney acknowledged Trump had made such statements but claimed they were generalized, Judge Chen pulled up specific quotes. She read aloud from a Truth Social post where Trump wrote, "My lawyers reviewed everything and told me specifically that I had absolute authority and that the plan was completely legal." Judge Chen asked how that statement could be characterized as too general to waive privilege when it disclosed both that lawyers reviewed the plan and concluded it was legal. Trump's attorney attempted to argue that Trump was paraphrasing rather than quoting, but Judge Chen noted that defendants can't retain privilege protection while publicly characterizing their lawyer's advice. That's when the hearing shifted from legal argument to what one CNN legal analyst called judicial evisceration. The courtroom moment that defined the hearing came about 90 minutes in. Judge Chen asked Trump's team point blank, if your client can publicly state his lawyers told him his conduct was legal, why can't the prosecution cross-examine those lawyers to determine if that characterization is accurate? The ensuing silence lasted nearly 30 seconds before Trump's attorney attempted to argue that fairness required allowing Trump to present the advice of counsel defense while limiting prosecutors' access to communications. Judge Chen responded with what legal reporters described as barely contained frustration, stating, "Counsel, that's not how evidence law works. You don't get to use privileged communications as a shield and a sword simultaneously." This moment crystallized why Trump's last defense strategy was legally untenable. The advice of counsel defense requires full disclosure, but full disclosure would expose communications where lawyers warned Trump his plans were illegal. This isn't the first time Trump has faced the impossible choice between asserting defenses that require privilege waiver and maintaining privilege to protect damaging communications. Think back to the Manhattan District Attorney's investigation into Trump's business practices, where Trump's attorneys initially suggested an advice of counsel defense for accounting treatments, but abandoned it when prosecutors demanded full waiver. Trump's team recognized that complete disclosure would reveal warnings from accountants that certain treatments were questionable. Similarly, in the New York civil fraud case, Trump considered claiming he relied on accountants' valuations, but withdrew that defense when Judge Engoron ruled it would require disclosing all communications with financial advisors. The pattern showed Trump's team repeatedly floating advice of counsel defenses, only to abandon them when courts required full waiver. Then there was the Mar-a-Lago classified documents case, where Trump's attorneys initially suggested Trump relied on legal advice about declassification, but never formally asserted the defense. Legal experts speculated the defense was abandoned because full waiver would expose communications where lawyers told Trump he couldn't unilaterally declassify documents by thinking about it. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget the January 6th case, where Trump's team considered asserting he relied on John Eastman's legal advice about the Electoral Count Act, but abandoned that defense after Eastman's own communications were obtained, showing Eastman himself doubted the legal theories he was advancing. Each time, the pattern was the same. Float the advice of counsel defense to suggest legal justification, then abandon it when courts require disclosure that would reveal lawyers' warnings. Now, however, Trump can't abandon the defense. Judge Chen's February 11th ruling holds that Trump already waived privilege through his public statements, meaning prosecutors can access and use the attorney-client communications, whether Trump formally asserts the advice of counsel defense or not. The pattern of using privilege selectively has finally caught up with Trump in the form of a judicial ruling that strips the privilege entirely. So what exactly did Judge Chen's ruling hold, and why is it so catastrophic for Trump's trial prospects? The opinion's analysis spans 91 pages divided into 3 sections, each independently fatal to Trump's defense strategy. First, Judge Chen holds that Trump's public statements discussing his lawyer's advice constitute a knowing and voluntary waiver of attorney-client privilege for all communications related to the topics he publicly discussed. The ruling catalogs 34 separate instances where Trump disclosed privileged communications through interviews, social media, and rally speeches. Judge Chen writes that when a defendant repeatedly and publicly characterizes his attorney's advice to support his narrative of innocence, he cannot then prevent the prosecution from examining the actual communications to determine if his characterization is accurate. This holding means prosecutors can now subpoena Trump's 5 designated attorneys, question them about every conversation with Trump regarding the alleged conduct, and introduce evidence of warnings Trump ignored. Here's the kicker. The ruling specifically addresses Trump's attempt to limit waiver to only favorable communications. Judge Chen rejects what she calls selective waiver, holding that once Trump waived privilege by publicly disclosing communications, the waiver extends to all communications on the same subject matter. This means prosecutors aren't limited to the 3 attorneys whose declarations Trump submitted. They can access communications with all attorneys who advised Trump on relevant topics, including attorneys who warned Trump his plans were illegal. The ruling includes a footnote citing specific evidence suggesting at least 2 attorneys warned Trump his proposed actions would constitute federal crimes. Warnings prosecutors can now introduce at trial. Don't go anywhere. The most explosive part is coming next. Second, Judge Chen rules that Trump cannot assert the advice of counsel defense at trial because the evidence doesn't satisfy the defense's requirements, even if privilege were maintained. The opinion notes that advice of counsel requires full disclosure of relevant facts to attorneys, but prosecutors have evidence that Trump deliberately withheld information from his lawyers to obtain favorable advice. Judge Chen writes, a defendant cannot manufacture an advice of counsel defense by deceiving his attorneys about material facts and then claiming he relied on advice rendered on the basis of those deceptions. The ruling references specific instances where Trump allegedly failed to disclose relevant information to attorneys, obtained preliminary advice, then proceeded with plans without updating attorneys about changed circumstances. This means even if Trump hadn't waived privilege through public statements, he still couldn't assert the advice of counsel defense because the evidence shows he didn't satisfy the defense's requirements. And here's what makes this particularly devastating. Judge Chen's ruling means prosecutors can introduce evidence of Trump's communications with attorneys, not to allow Trump to defend himself by showing he relied on advice, but to prove Trump's criminal intent by showing he deceived his lawyers and ignored warnings. The communications Trump hoped would exonerate him will instead be used as prosecution evidence of consciousness of guilt. This puts Trump's legal team in what legal experts describe as an impossible situation from which there's no escape. The advice of counsel defense was their entire trial strategy. They planned to present Trump's attorneys as witnesses, explaining they reviewed Trump's plans and concluded the conduct was legal. They expected to argue to jurors that Trump, as a non-lawyer, reasonably relied on expert legal guidance. Now, that strategy is not only foreclosed, but reversed. Instead of Trump's attorneys testifying for the defense, prosecutors will call those same attorneys as prosecution witnesses. Instead of attorney communications supporting Trump's innocence narrative, those communications will be used to prove Trump knew his conduct was illegal because his lawyers told him so. And there's no way to reconstruct a defense strategy 1 month before trial. The trial is scheduled for March 18th. Trump's team has 5 weeks to prepare a completely different defense, identify new witnesses, develop new cross-examination strategies, and create new opening and closing arguments. Legal experts note that defense teams typically spend 6 to 12 months preparing for complex federal trials. Trump's team now has 35 days to start over from scratch. Legal analysts say this is the most devastating pre-trial ruling in modern federal criminal prosecution history. Barbara McQuaid, former U.S. attorney and University of Michigan law professor, told MSNBC that Judge Chen's ruling eliminates Trump's only remaining defense theory and turns his greatest asset, his lawyer's advice, into the prosecution's most powerful evidence of criminal intent. She explained that juries are skeptical of advice-of-counsel defenses, even when properly asserted. But when prosecutors can show the defendant deceived his lawyers and ignored their warnings, that defense becomes devastating evidence of guilt. A former federal prosecutor who tried white-collar cases for 20 years added that defendants almost never recover from rulings like this. He noted that once a judge eliminates your core defense theory and rules that your privileged communications will be used against you, the calculus shifts entirely from trial strategy to plea negotiation. Most defendants facing this situation plead guilty rather than go to trial defenseless. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Alan Dershowitz, defense attorney and frequent Trump defender, acknowledged the ruling creates severe problems. He told Fox News that while he questioned some of Judge Chen's legal reasoning, there's no doubt the ruling removes Trump's primary defense and creates a very difficult trial situation. Dershowitz noted that appealing the ruling would take months and likely wouldn't succeed, meaning Trump faces trial without the defense strategy his team spent months developing. So, let's break down what this means going forward. First, the immediate impact on trial preparation is catastrophic. Trump's legal team must completely abandon the advice-of-counsel strategy they've been developing since December 2024. Every witness they plan to call to support that defense becomes unusable. Every cross-examination question designed to elicit attorney advice becomes irrelevant. Every exhibit they prepared showing Trump consulted lawyers is now useless or worse, harmful if it shows Trump ignored warnings. The team must identify an entirely new defense theory, draft new motions in limine, prepare different witness examinations, and restructure their entire case in 5 weeks. Second, the ruling's disclosure of attorney warnings creates new prosecution evidence. Judge Chen's opinion references evidence that at least 2 attorneys warned Trump his plans would constitute crimes. Those attorneys can now be called as prosecution witnesses to testify about those warnings. The prosecution's case will likely include testimony from Trump's own lawyers explaining they told Trump his proposed conduct was illegal, that he proceeded anyway, and that he later publicly mischaracterized their advice to claim legal justification. This transforms Trump's relationship with his attorneys from a defense asset into prosecution evidence. Third, the political implications are devastating because the ruling eliminates Trump's narrative that he was following legal advice. Trump has spent months telling supporters he relied on lawyers who confirmed everything was legal. That narrative collapses when a federal judge rules Trump waived privilege and prosecutors can prove Trump's lawyers actually warned him he was planning crimes. Republican officials who defended Trump by citing his reliance on counsel must now explain why they're backing someone whose own lawyers warned him he was breaking the law. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate legal and political consequences, this ruling is about whether defendants can manipulate privilege protections by publicly disclosing favorable communications while hiding unfavorable ones. Attorney-client privilege exists to enable confidential communication so defendants can obtain candid legal advice. But that privilege becomes a tool for deception when defendants publicly characterize advice to support innocence claims while invoking privilege to prevent exposure of warnings they ignored. Judge Chen's ruling establishes that defendants who publicly disclose privileged communications waive protection for all communications on that topic. If defendants could selectively waive privilege, they'd weaponize confidential communications by disclosing advice that helps them while concealing warnings that hurt them. This scenario has created absolute panic within Trump's remaining legal team and political operation. Reports indicate that Trump's attorneys held an emergency meeting on February 11th, immediately after Judge Chen's ruling was published, with several attorneys reportedly expressing concerns about their own legal exposure now that they may be called as prosecution witnesses. Sources told CNN that 2 attorneys on Trump's team are considering withdrawing from the case because they may need their own counsel to navigate the privilege waiver implications. Meanwhile, Trump himself responded with fury. A Truth Social post at 9:23 p.m. on February 11th called Judge Chen a radical Obama judge who just destroyed the Constitution and attorney-client privilege and claimed the ruling proves the entire system is rigged and corrupt. Trump specifically stated he would appeal immediately, and this unconstitutional ruling will be overturned. Though legal experts noted that interlocutory appeals of evidentiary rulings are rarely granted and even more rarely successful. The political operation is scrambling to message the ruling to supporters in a way that doesn't concede the underlying weakness. Republican surrogates have been instructed to attack Judge Chen as biased rather than address the legal reasoning, and to emphasize that Trump's lawyers gave him advice without acknowledging they also gave warnings. Stay with me. What comes next will completely change how you view the situation. Here's what makes Judge Chen's ruling even more devastating than it initially appears. The opinion includes a detailed evidentiary analysis revealing that prosecutors possessed specific communications where Trump's attorneys warned him. Page 67 includes a footnote stating that one attorney told Trump via email on a specific date that the proposed plan would almost certainly constitute obstruction of justice and could result in criminal prosecution. Another attorney, according to the ruling, told Trump in a recorded phone call that proceeding with this plan is legally indefensible, and I cannot in good conscience provide advice supporting it. These aren't vague warnings about legal risks. These are categorical statements from Trump's own attorneys that his plans were criminal. And because Trump waived privilege by publicly claiming his lawyers approved his conduct, prosecutors can now introduce these warnings as trial evidence. Legal experts immediately recognize this as the death blow to any viable defense. Former federal judge Nancy Gertner told the New York Times that once prosecutors can show Trump's own attorneys warned him conduct was criminal, the intent element of the charges becomes nearly impossible to contest. She explained that criminal intent requires knowing your conduct is unlawful, and contemporaneous warnings from your own lawyers proves that knowledge definitively. This goes far beyond one criminal case or one evidentiary ruling. It's about whether the attorney-client privilege retains meaning when defendants publicly weaponize privileged communications. The privilege exists to encourage frank discussion between clients and attorneys, enabling effective legal representation. But when clients publicly disclose those communications to shape public narratives, while invoking privilege to prevent scrutiny of whether their public characterizations are accurate, the privilege becomes a tool for propaganda rather than a protection for confidential consultation. If defendants could selectively waive privilege, every defendant would publicly announce, "My lawyer said this was legal," while preventing prosecutors from examining whether lawyers actually said that or instead warned the conduct was criminal. Once selective waiver becomes viable, privilege transforms from a protection enabling confidential advice into a weapon for manufacturing false innocence narratives. It's not just about Trump. It's about whether privileged communications remain genuinely confidential or become strategic resources defendants can deploy partially to mislead while preventing complete disclosure. If this blows your mind, hit that like button right now. Here's the situation. Judge Chen issued a 91-page ruling that eliminates Trump's last remaining defense strategy by holding he waived attorney-client privilege through public statements that he cannot assert advice-of-counsel defense because he deceived his lawyers and that prosecutors can use his attorney's warnings as evidence of criminal intent. Trump's legal team has 35 days until trial to develop an entirely new defense theory after spending months building a strategy that's now completely foreclosed. This is no longer a case with multiple viable defense options. This is a defendant going to trial defenseless because his final strategy was eliminated by judicial ruling. When federal judges rule that your privileged communications will be used as prosecution evidence, proving you knew your conduct was illegal, you're not heading to trial. You're heading to conviction. Keep a close eye on whether Trump's team attempts emergency appeal of Judge Chen's ruling. Though legal experts say interlocutory appeals of evidentiary rulings are rarely granted, and the March 18th trial date makes timing nearly impossible. Watch for signs that Trump's attorneys begin plea negotiations, which would be the rational response when your defense theory is eliminated and your trial is 5 weeks away. Monitor whether additional attorneys withdraw from Trump's team as the privilege waiver creates personal legal exposure for lawyers who may be called as prosecution witnesses. And pay attention to whether Trump's public statements change now that every discussion of his lawyer's advice constitutes additional privilege waiver. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. Trump's last remaining defense strategy has been completely eliminated by a federal judge who ruled he waived privilege, cannot assert advice of counsel defense, and that his attorney's warnings will be used as prosecution evidence. The March 18th trial is 35 days away, and Trump's legal team must completely restart their trial preparation with no viable defense theory. Meanwhile, Judge Chen's ruling reveals prosecutors have evidence of categorical warnings from Trump's lawyers that his plans were criminal, evidence that will now be introduced at trial to prove Trump's criminal intent. This isn't just another adverse ruling in a long series of legal setbacks. This is the elimination of Trump's final hope for acquittal with no time to develop alternatives. What happens next could determine whether Trump's team attempts a last-minute appeal that likely fails, pursues plea negotiations to avoid trial, or proceeds to trial defenseless and faces near-certain conviction. The ruling is published. The privilege is waived. Now, we wait to see if Trump's attorneys can construct any defense in 35 days, if they negotiate a plea to avoid guaranteed conviction, or if Trump proceeds to trial with no strategy beyond attacking the judge in process. We wait to see his own attorneys take the witness stand as prosecution witnesses testifying about the warnings they gave. And we wait to see whether Republican officials continue defending someone whose own lawyers told him his conduct was criminal. The stakes have never been higher. The defense options have never been more completely exhausted, and the path to conviction has never been clearer and more inevitable. Pause for a second and hit that like button if you're finding value in this coverage.